Good morning, ladies and gentlemen. I'd like to call this Wednesday, February the 7th, 2024 of the Property and Planning Subcommittee to order. Ms. Clerk, will you please take the roll?
Representative Martin. Here. Representative Raper. Here. Representative Reedy. Here. Representative Rudd. Here. Representative Thompson. Here. Representative Wright. Here. Chairman Crawford. Present. Chairman Carr.
Here.
Chairman Carr, you have a quorum.
Thank you. Do we have any personal orders from anyone on the committee this morning? Seeing none, I want to make one announcement. If people see some of us getting up and leaving the diocese and going out and coming back in, it's not because they're just leaving. It's because we have other people that have to present bills in other committees, and sometimes they have to step out. They have no choice and come back in. We're not trying to be rude or anything. I just wanted to make that announcement there. We had 5 bills on the agenda today, but I will go over the bills with you real quick so that you'll know that item number 2, House Bill 1535 by Bricken, has been taken off notice. Item number 3, House Bill 2140 by Butler has been rolled 1 week. And item number 4, House Bill 969 by Thompson has been taken off notice. That brings us back to the start of the calendar. Item number 1, House Bill 2071 by Chairman Williams. Chairman Williams, you're recognized. I have a motion and a second. You're probably recognized.
Thank you, Chairman and members. House Bill 2071 is not new to this committee or the House and the Senate. Back in 2018, my local community, along with the planners across the state, were concerned about economic and community development in their districts when it related to properties which were outside the city limits, which were in the growth boundary, but were contiguous with the city line between the city and the county. What this bill seeks to do is to reenact that provision that was passed in 2018 by this body, which would allow, instead of allowing for annexation to only be by referendum, if you had a business, for instance, that wanted to come into community and it was adjacent to the city line, and they wanted to extend plan of services, water, sewer, electric, and things like that. In my community, all those services are provided by the city of Cookeville to its citizens, both inside the city and in the county. What this bill would allow to do, a provision for less than 9 properties. It could only be 1 property if it could be. It was the tenets of it, and if they could vote by paper ballot instead of waiting on the next referendum. In local communities, particularly in rural ones like mine, the cost of standing up a referendum for an economic and community development project would be costly. It would also slow down the process. This just gives an opportunity for 9 or few parcels to do that. It would require, of those 9 or fewer parcels, it would require not a simple majority, but a 2/3 majority for that property to be able to come into the city. And then, of course, the city would have to provide plan of services, fire and water services there as well. That's the description of the bill. There's been a little bit of discussion as to whether or not my friend and fellow colleague of ours was supportive of this bill. And most of the members of this body, I have submitted to you the vote tally and how I worked with him. Originally, it was his idea to do 9 or less parcels. And he requested that we move it to a 2/3 majority. And so, as you can see from the information I provided you in 2018, he was very supportive of that. I'm happy to answer any of the questions that the members might have.
Thank you, Chairman Williams. I have first on my list Representative Martin. Representative Martin, you're recognized.
Thank you, Chairman Williams. I appreciate you coming and presenting this to us. I have a couple of questions, though. As I look at this is another example where you're going to have an opportunity for forced annexation of people that don't want to be annexed into the city. Now, I'm reminded of Ronald Reagan's great words: the 9 worst words you could ever hear is, "I'm here from the government and I'm here to help." And I think there's probably a lot of people that are very nervous about this bill. I've been inundated with emails and texts about this bill because they're afraid that they're going to be forced to be a part of a government that they don't want to be a part of through this. And, I think for some people, the single worst experience that they've ever had with government is when they were annexed in. They were peaceful, law-abiding citizens. They were never asked to be conscripted into the military, but they feel like they're being brought into a government that they don't want to be brought into, in a local government. And I remember when the annexation bill was passed a number of years ago, my neighborhood is right on the edge. And we didn't get annexed. But others neighborhoods of people that I represent were, and they were, to the vast majority, were not happy about it. I'm sure there was some people, but not many. And so the question I have is when this bill was passed, there was a sunset put on that provision about the 2/3. Why was that sunset put on, and why was that not addressed last year? Because the sun is already set for over a year. So why was it put on, and why was it not addressed last year is my first question.
Chairman Williams, you recognize.
Thank you. The reason why the original sunset provision was on the bill back in 2018 is because Chairman Carter, Judge Carter, however you like to talk to him, he and I were concerned that maybe there might be an instance where local communities would take advantage of this, and it would be a detriment to those people in those communities. So we said, well, let's just try it for a short period of time, see if it works. In my case, in my community, it did work once because we had an employer that wanted to come there. And so that was the reason why the original sunset provision was put on there. In the regular operations of life, we completely forgot that the sunset was on there. My community seek to try to do this process for an employer that they actually lost. It was them, my local community, that contacted me and said, hey, did you realize the sunset? And I said, no, I'd completely forgot that we put a sunset on it. And so that's the reason why the sunset was on there, is so that we make sure it worked and it wasn't ineffective or people didn't take advantage of it. And the reason why it was able to sunset is because I missed it, my community missed it, and therefore the whole state was impacted by its automatic repeal in the sunset. All this does is reestablish that practice that had been in place for 5 years, which is what the original sunset was.
Representative Martin.
Well, as I read that original bill, which is Public Charter 1047, the sunset was not put on the first part that says that all of the property owners within the territory proposed for annexation that consent in writing, they can be annexed. That did not have a sunset on it. But the sunset is on this 2/3 aspect of the property owners. My question is this, though. Why are we making this property owners instead of qualified voters who would make this decision? And here's where I'm going with that. You could have property owners from China or from some other country that wants to buy property. I know there's been a lot in the news about a certain group that's bought property in Hamilton County that are foreign investors. And so you have property owners, not voters, making a decision. These people, they may have never stepped foot in Hamilton County. They may have never stepped foot in the state of Tennessee. And yet the property owner, if I read this right, has as much or more say than the qualified voter who's lived in that community perhaps their whole life. So why are we allowing a property owner instead of a qualified voter, a citizen, someone who's put roots down, to make decisions like that? That's my first question.
Chairman Williams.
There's not a provision as it relates to whether there should be a requirement to be a qualified voter. The reason why Chairman Carter and I did it this way is because we tied it to the number of parcels, and the property owner is the parcel owner. And so in that instance, whoever owns the property, whether they're make that parcel their full-time home or whether it's, a farm or a second home was irrelevant to the discussion that we had. As it relates to Chinese investment, I really can't answer that question. I don't know how it applies in this instance.
Well,
Representative.
Well, my point is this, is that you could have someone that goes and buys a parcel of land and they divvy it up into 5, 6, 7 parcels. They've got the 2/3 majority. And that lady who has lived, or that family that's lived there on the edge of the city and has never been annexed, doesn't want to be annexed, all of a sudden they're the voter, they're the citizen, they're the ones that pay the taxes. And you have people that maybe aren't even American citizens. All they are is property owners. They're not voters. They're not citizens, and citizenship means something. But they're the ones that get to trump what happens to those parcels. I think it ought to be voters, qualified voters that are making these decisions, like we do if a neighborhood wants to be annexed and they have a referendum and the neighbors get to decide that because they go to church together, they go to the pool together, they do life together. Not somebody who they've never met before, who's just a property owner that perhaps lives out of state or out of, you see my concern there?
I hear the words that you're saying. In this instance, I'm not tracking where you're going because in this instance, it's the property owner that votes. In the instance you're talking about, it's the property owner that votes. The only difference is this is done through communication and a paper ballot with the local community instead of having a referendum. It's simply an exception to the rule that this body felt like was acceptable at the time, that no one in the state of Tennessee has taken much, has utilized very often, but in the instance of my community, it was an effective remedy in order to do that, so that it doesn't happen where someone's trying to get an employer to come to their community to add jobs and to pay more taxes and improve the property for both county and city. This would allow them to do it in an expeditious manner, and that's simply what the bill does.
I'll wrap up with this. You know, to me, if and I want to be on record that against this, and others that are against it, I hope that here's my concern. If you did this, and that individual who's lived there forever, and they don't want to be in the city, and they're going to be taken in because the parcels have been sold to somebody who may or may not live in the community, but they're not a voter there, that at the very minimum, the people that represent those individuals that don't want to go in, that are on the county commission, the ones that they've elected to represent them in local government, the county commission, the county commission should have a say as to whether this is a part of going into the city. And if the city is going to have this annexation policy, that at the very minimum, they should have a de-annexation policy that mirrors it. So that if you have this 2/3 can get in, they ought to have a policy where 2/3 of property owners could get out. But I'm against this as it's written. And, but I thank you for bringing these thoughts before us.
Thank you. Chairman Williams?
Thank you. Just in response, there is this body passed last year the ability for people to be de-annexed, and that is a property. And you can simply do it by simple property owner. As it relates to your concerns, as it relates to the Planning Commission, I think it's a really slippery slope when either a city or a county has to get approval from someone from the other entity to either annex property or not. But that really, because you brought that up, that's a separate bill that's in finance right now. We've had a little bit of discussion about that, and I look forward to further discussion. But that policy that you described does not apply to this bill.
Thank you. Representative Thompson, you're recognized.
Thank you, Mr. Chairman. Well, annexation's been a big issue for a long time in my county, in my city, and even especially in my district, because, you know, I'm in, well, at least part of what I represent was de-annexed a few years ago. Even though I'm not for returning to annexation by ordinance that we had previously, we've, I'm not a hardliner either. I could see some room for doing this. In fact, one part of my district has the Jewish home, which is a fairly large nursing and rehab home in my area. And under the old law, the owners requested that they be annexed because they wanted a better fire protection, better emergent EMS protection, and went through, and the city did annex them. They sort of stretched the line a little bit and annexed them. And I can see under current law that to do that, as I understand it, they would have had to have a referendum, I guess, of the residents of that nursing home who have absolutely no idea what all the issues are, as opposed to the owners of the nursing home doing that, which I think under this law they could do. But on the other hand, I'm not totally comfortable due to some of the reasons that Representative Martin mentioned on having property owners having the total say, that we're sort of ignoring the residents. And again, I can see some leeway on this because there are the way annexation, when the new law took effect, it caused some problems in my area. You'll find next door neighbors. One might be in the city and one in the county, and those in the county might be taking advantage of all the city amenities without paying the taxes. So that's another thing. But I think overall, I'm not totally comfortable with this bill as written. If it were written possibly in a little bit different way, I could potentially be supportive. But for now, I don't think I can support it.
Chairman Williams, response?
Well, I think property owners' rights is one of the most protected portion of what we do. And so I think, as it relates to who owns the property, I think they're the best posture, the best place to make decisions. And because they own the property, they should be the ones to make that decision. So I recognize that you have concerns with it. I'm happy to work with you to try to alleviate those or any of the members that they might have. But because this was the language of the original bill and because it was discussed with my good friend, I felt like that changing it would be very problematic. So happy to answer any questions you might have.
Thank you. Representative Martin, your name was mentioned. Would you like any further question?
Well, the only other thing I was going to say is that when Chairman Williams had mentioned about one government approving another, I understand that. My point is that individual that is not in the city, their only elected representative locally that they voted for in the legislative body is their county commissioner. It's not the city council, it's their county commissioner. And I think that we respect local government, all of us do. And my point is that they should have a conversation, and that's where they're there to represent them. That's all I would say.
Thank you. That was a little off the bill, but that's okay. We'll get to that subject a little bit later. Anything else? Anybody else have anything they want to say on this bill before we vote? Are we ready to vote? All those in favor of House Bill 2071 moving on to full, say aye. Aye. All those opposed?
No.
Roll call vote. Madam Clerk, take the roll.
Representative Martin,
No.
Representative Raper,
No.
Representative Reedy,
Present.
Representative Rudd,
Yes.
Representative Thompson,
No.
Representative Wright,
Yes.
Chairman Crawford,
Yes.
Chairman Carr,
Yes.
Chairman Carr, 4 ayes, 3 nays, 1 present not voting.
I believe that passes, doesn't it? Bill moves on to full committee. Thank you, sir. Next we have, I'm going to pass the gavel over to Chairman Crawford. It's my bill. Chairman Crawford, you're recognized.
Thank you. We're on item
Thank you, Mr. Chairman. And I know this is, I'll present the bill first, and I do have one that wants to speak before they have to go to another meeting, if you will allow that, please. This legislation, first of all, is a comptroller bill. It's called the Reevaluation Modernization Bill. And let me say up front, the very first thing, this is not a revenue bill. It's a revenue neutral. What we do now is when we do our evaluations in our hometowns and our counties, we do it on a 4, 5, and 6 year period. Okay? All this does is it puts it on a 1, 2, 3, or 4 year period. You can reevaluate them on the first year, second year, third year, fourth year, and you're not going to lose anything that way, because if your value goes up, your mill comes back down, and your taxes, your property taxes stay neutral. And all that does is gives the counties opportunity to reevaluate sooner and quicker and get their values of their property up. And that's what this bill does. I know some of them, and I'm gonna bring it out. Somebody said that there's a little physical note on this from physical review. We're gonna talk to them about that because they do not understand, and I will say that on record. This is a revenue neutral bill. It does not raise taxes. Thank you, Mr. Chairman.
You've heard the explanation of the sponsor. Are there any questions for the sponsor? Representative Raper, you're recognized.
Thank you, and I'm gonna be as brief as possible because I've got to go present two bills. But I want to say, number one, I am totally in support of this. Bradley County was the first to bring this to the comptroller's mind, and we took a look at this. And there are a couple of things I want to say about it. Number one, it gives you an option. I think that is so important that we're not just delegating a number of years, that it gives the local government an option. Next thing is this, and this happened in Bradley County. If you are on a 5 or 6 reappraisal number of years, then what happens is it is hard to budget for that for the county commission. And what happens is you get to a point where you're in the hole $1 million or more dollars and trying to make that amount up, and it's very difficult. And it's also difficult on those that are being reappraised, because sometimes instead of dividing it up over a smaller amount of years where you can see each year and sort of plan for that, and then what happens is you have a large number of years, and then everybody wants to know, why in the world has my property taxes gone up to this amount? Well, if it's happened over a smaller amount of years, then it's not near as noticeable. And I'll give you one analogy. It would be just like if you were paying your car taxes and your homeowners, and they were bundled, and they came and said, there will be no difference in price whether you pay this annually or you pay this monthly. Well, about everybody is going to choose monthly because it gives you options. So thank you very much, and I'm total support.
Representative Thompson.
Thank you, Mr. Chairman. I think my question may have been answered, but I'll just ask for the record. This does give options of 1 to 4 year reappraisals for individual county board or property assessment.
Chairman Carr.
Thank you, Chairman. Yes, that is correct.
Okay.
Any
Okay,
other
thank
questions
you.
for the sponsor? Seeing none, we're ready to vote. All those in favor of moving House Bill 2057 on, please say aye. Aye. Opposed, no. Bill moves on.
Thank you, Chairman and committee. That's all right. Chairman, go ahead and dismiss. You can do it. Go ahead.
Go right ahead. You got it.
Anything else to further come before the Property and Planning Committee Subcommittee today? Seeing none, we are adjourned.
That was good. I like that.